like to initially thank the Institute and the IIC and Dr. Kamlesh for giving me this opportunity and letting me share my thoughts with this amazing crowd. And also thank you to my dear friend Mr. Vijay for connecting me and Dr. Kamlesh. So without taking a lot of your time, I would like to start with the session. I'll just quickly share my presentation. Okay. So when Dr. Kamlesh asked me to talk about IPR, I was like, I'm not probably the right person to talk about the basics of IPR because I'm not a patent agent. A better person would definitely be Mr. Vijay. But then when I gave some more insight into it, and I thought that, okay, why not? Since I have filed for multiple patents and I have a few one granted patent and two in process plus a few granted trademarks, and I have been in the startup ecosystem myself, being a co-founder, and there the burnt of not having my IP strategy well. So probably I'm actually the right person to talk about various IP strategies that we can, we as young entrepreneurs or new entrepreneurs, we can take into account. So why startups and IPR go hand in hand? Now, whenever we talk about startups, the first word that comes into our mind is innovation. And whenever we talk about innovation, definitely innovation and IPR I say they're kind of synonymous. So whenever we have an innovative idea, this is the innovation is something that is the one word that differentiates from a general routine business from a startup. Startups are generally something which are more on the innovative front and newer ideas. So when you say that, okay, I want to have a startup, you definitely have a new idea, you have an innovative idea. And since I am talking in front of a crowd which comes from a technical background, pharmacist or future pharmacists who are into product development or new chemical entity development, definitely there is a lot of innovation involved here and a lot of intellectual property. Now, often when we are starting a startup, there are 10,000 different things to be done. Making a team, developing the product, getting into this all legal aspects of it. And in this, there are so many things to be done. The founder is so busy. Often, a lot of times, we forget about the IPR. We forget that, okay, we have an intellectual property which we are willing to commercialize in the coming 4 5 years, and we kind of forget to protect it. So, why this is important? Now, before we get to why intellectual property is important and an integral part of building your startup, I would just quickly spend like around 2 3 minutes on what are the different types of intellectual property. I don't really want to go into detail because types of IPR is covered in your syllabus, and plus I'm sure the IIC must have already conducted a few sessions on details of IPR. So broadly, when you say intellectual property, is something which is an intangible asset. Your house or the house, your cell phone, these are all your tangible assets, which has a value, which has a monetary value. But then intellectual property is something an intangible asset, which definitely has monetary value in future when you want to commercialize it. So broadly, it can be divided into copyright based, which is more of the literally or the artistic. I'll not probably look into this, but then we'll more talk about the industrial copyright, which consists of your copyright, the trademark, patents, industrial design, and geographical indication. Quickly coming to what exactly are copyrights, I'm sure you all are aware of what exactly are copyrights, but then just to give you an idea, these are the rights of the author which is protected. So say if you write a book or if you write an article or there is some paraphrase that you're writing. So if these sort of or technical drawing, these type of things can be protected through copyrights. Then comes your trademarks, extremely important when it comes to marketing your product or commercializing your product. So when you have your trademarks, say the logo of your company, the name of your company, it could be the way your company name is written, the font, all these things could be trademarks. And why these are extremely important is because, say for example, Coca-Cola. Now, Coca-Cola is a very well-known trademark. It's a brand. It's a well-known brand. It's a well-known trademark. I cannot come up tomorrow, just get up and make another drink with the same name or any other product with the same name of Coca-Cola. So here, why trademarks are important is because the trademark or the logo, the name of your company is going to be the identity of your company, identity of your product. And definitely in future, if you plan to go big, you do not really want someone else to come up with a similar range and name and infringe on your property. Next comes patent. Patent, I'm sure you all know about it. I majorly want to talk about at what different stages of startup, what different IPR strategies you can apply. But then, so patent is basically exclusive right to a particular product or solution. Generally, patents are granted for a period of 20 years. So once you have your patent granted, there are certain rules how it can be granted, like what all exactly are covered, how what your patent could be granted for. So once your patent is granted, from the date of application till 20 years, you get exclusive right for commercializing or selling your particular product or service. Then comes the geographical indication. This is more of, say, something which has origin. So we all know about the turmeric case which Dr. Mashelkar fought, and he got the GI for turmeric for India. So similarly, Darjeeling tea is a geographical indication, which signifies that that particular product of natural origins. It could be a plant, some processed material of the plant, say basmati rice, or recently there was a big fight between Odisha and West Bengal for the Rasgulla. So now we have two GI indication. One is the Odisha Rasgulla and one is the Bengal Rasgulla. So that is your geographical indication. Last part is your industrial design. This could be something of a 3D structure, say probably how your medical device will look. So you have these glucometers. So the shape of the glucometer that could be covered under medical device. Simplest example could be the bottle of Coca-Cola. It has evolved over the years since the inception of Coca-Cola. It has evolved over the years. And you can see that no other cold drink manufacturer has a bottle which is similar to Coca-Cola. That's because their bottle design is protected by industrial design. So their intellectual property is protected. Next comes your trade secrets. This is more of not really filed, but then it's something that you keep within the company in order that so that your trade secret is protected. Example again is Coca-Cola. So the formula of Coca-Cola no one knows apart from the top executives. So they don't really want to patent the formula because if it's there out, anyone can go and manufacture it by varying the combination little bit here and there. But then they want to keep it a secret, so they never let it out in open, except from the. And there are multiple ways we'll see how you can let your employees or your founders get into this trade secret. We'll see it in the coming slides. Now, when we talk about patents and IPR and startups, I just want you all to answer a few questions. Now, will patents facilitate venture capital investment? Now, what is this venture capital investment? Simply, so you have shares in the company. Now, there will be a venture capitalist who is ready to invest in your company based on the idea, based on the people who are there in the company. Now, if you have a patent, granted patent, or even a filed patent which looks very promising to be granted, will it increase my chances of getting investment by a venture capitalist? Next question will be, will it help me defend against different rivals who come up with a similar product? Or also, will it help me stop theft of innovation by a very big company? So say a startup is a small company initially. If they are lucky enough, they'll grow big into unicorns. But then a smaller company, what they develop, maybe a similar bigger MNC who has a lot of resources at hand, could end up stealing their idea and getting your idea in the market at much faster rate than you can. So in this sort of a scenario, can a patent or an IPR help to stop that theft? Also, can a patent help you rapidly increase your market share? Can it help you in forming some joint venture R&D partnership with various organizations? And what are the chances if you have a patent granted? Is there a chance for a startup to be acquired? So a lot of times this is a trend which goes on. The startups, they establish a company, the founders, they establish a company, they make the product, they generate the product, they get it into the market, and once it picks up, the founders usually let the startup get acquired by any other bigger company, and they work on a different idea. So this is what basically, in a nutshell, acquiring is. And it's a lot of times very good for the product, because if a bigger company is acquiring your startup, it helps your product to reach the masses at a faster pace and at a larger scale, obviously. So if you have a patent, will your chances of getting acquired increase? Also, patents, can it help you get ready for an IPO? IPO is initial public offering, wherein a startup. So recently, you must have read in the newspaper, Burger King launched its IPO. Mrs. Best Vector Foods launched its IPO. So IPO is initial public offering, wherein you get listed in the stock market. So from private limited, you become a public limited company. So all these questions, the answer to all these questions about is yes. So in a nutshell, if you want your startup to succeed in a long run, uh, IPR is one of the way and one of the most important ways to get through it. So we've talked about what are the general common IPR, types of different IPR, and why it is important and how it could help you to grow your startup. Now, I'm assuming that the crowd here is majorly students or researchers or faculty researchers who would be starting with their startup, or probably have their IPRs or a patent, or they have some innovative ideas and they want to convert them into a startup. So rather than talking a strategy as a whole, I would like to divide a startup life cycle into various events, key events, and then I would like to tell you all at what particular key event, what different strategies or what IPR you should look at, and what could be the resources that you could use. Okay, so a company life cycle, a startup life cycle could be majorly divided into first step when the company is founded, then you hire your first employee, your product development is completed, or you start with a new product development to release your product in the market. You're actually marketing the product, and then maybe you're talking to a potential strategic investor or some strategic partnership. So as and when the company goes ahead and it grows in nature, your more and more IP strategies keep developing. But then probably for initial stages, I think this much is enough for new founders. So first event is definitely when you're finding your company, when the company is founded. So at this particular stage, the people who are involved will be you and the founders and your co-founders. So probably you start with one of your friends or two of your friends or some family member or maybe some acquaintance you started with. So what could be the intellectual property issues that will arise at this particular stage when you're finding the startup? So one is your core idea. Initially, when you have your startup, you have a core idea. Obviously, if you're making a startup, you have an idea, and that's why you want to build a startup around it. So you have your core idea. Then you need to find a name for your company. You need to register your company. You need to find a name for your company. Also, you have to name your product or service something. Then there'll be a technical know-how of the product or service that you're developing. So what are the intellectual property actions that you need to take at these cases? First thing is you have a core idea. You can patent your core idea. Now, this I have learned a very hard way. So we were developing from my second startup, Cerelia Nutritech. We are into IP-based product development. We are developing all patented products. We have around 7-8 products in the pipeline. So our first product when we were developing, we worked on it through our own money without any funds for around 6 months, and then we applied for certain grants. We got rejected for a lot of them. One clicked, and they wanted us to send. There was some email communication which was sent to all the 4 or 5 finalists, and they wanted us to send a document. Now I was very naive. I was stupid, naive, whatever you call. What I did, I replied to all of them and I sent a document which had all the details of my product. even the technical know-how, maybe not the 100% technical know-how, but then maybe some 60-40% of it. Now I was so scared. Now what will I do? Since there are other startup founders who in that email, and instead of sending it only to the grant manager, I sent it to the entire reply. I replied to all of them. So there were around like 15, 16 people in that email thread. So what we did was, so we were in a fix what to do. So what we did was overnight we had to file for a provisional patent so that the idea is protected. So we had a patent attorney. We contacted the patent attorney, and within like 2 days period, we filed for a provisional patent. So the learning here is basically whenever you get an idea, you're discussing it out with people. It could be your colleagues, it could be a funding agency, or it could be anyone, a prospective mentor, a prospective investor. So it's always better. Obviously, the grant of patent will take 3, 4, 5 years, but then you can file, and you might not have the entire data available to file for a full patent or a complete patent application. So definitely you can file for a provisional patent application. So as and when you get the idea, you have a little bit know-how. Okay, this is, you have some imagination that this is what my product is going to look like. This will be the key features. You can file a initial prior patent application so that your idea is protected and you get the advantage of that date. So I'm sure you all know how patents work. So the first one to file the patent, even say some other person is going to file the same patent on a similar idea or same idea. I file it today, the person files tomorrow. I'm going to get advantage of it. The next person to file, his patent would be rejected because mine is already filed. So I have a priority. Next is when you are deciding the name of your company. It is very, very, very important that you have your trademark clear. Now, why this is important is because first thing is when you want to register a private limited, or you'll probably register a LLP company. There are multiple types of companies. So when you register a private limited company, when you're registering it with Ministry of Corporate Affairs, I'll show you the site. So when you're registering it with Ministry of Corporate Affairs, they need a very unique name, which is not already existing. So for that, and the other thing is, since we are into technology, since we want to market this particular product, the trademark of the name of the company is extremely important. So a lot of times it does happen that you might not get the trademark for your company name. So in these cases, what happens is you miss out on a lot of opportunities to use your company name for marketing. Because if someone already has the trademark, they can come and file a litigation on you. So remember, whenever you're filing your company name, make sure that you have your trademark clear. Take some time, but then you should have your trademark clear. Next is you have your founders. Now, different founders, they will contribute at different levels. What about the IP ownership? Now, if you all must have read any patent, or if you have your own patents granted, you know that there are two parts of it. One is the inventor, other is owner of the patent. Inventor will be people who are contributing to it. See, for example, in my company, if I have a patent, if I'm going to file a patent, maybe I am there, one of my technical employee is there, and maybe some other person who are contributing to the patent. So we will be the inventors of the patent. But then the ownership of the patent will it's always better that it should lie with the company. So it will lie with my company, Career Limited Private Limited. Now, why this is important? See, when you're filing a patent individually, you do not have a company. So that time what happens is you are the inventor, you are the owner of the patent. But then if more than one or two people are involved in the process, are contributors for the intellectual property, if you want to, in future, if you want to commercialize your patent, who gets the monetary benefit of it? Who gets the right of it? So always the inventor and owner, you should have a very clear understanding who will be the inventor and owner. For this, you have your IP agreements, you have your founders agreement, and there are multiple people who help you out with such sort of agreements. And it is always better when you are starting, you have this founder agreement and the IP ownership very clear before you're going to file the patent. Then there's other thing which is domain name. When you're starting with a company, availability of domain name is extremely important, because you don't want that you name your company something and then you realize that domain name. So domain name is nothing but www.facebook.com. So that facebook.com is the domain name. So it's very important that the domain name is available, because then it will be very difficult for you to have your online presence, because people will search for your company and then land up on some other website, and then the customer will definitely lose interest. So I just want to give you some resources which you can use at your own end before hiring any particular person. Obviously, it's always better to hire. It's a must to hire a patent attorney unless and until you are experienced and you are formally trained for it. But then, so Vakil Search, India Filing, Clear Tax, these are certain. These are certain legal agencies who will help you in selecting a company name. They'll help you in selecting a domain name. So we coming from a technical background, we always get stuck in the legal aspects of a business. And it feels like a big task to file a company, to register a company, to register a private limited company, what to do with the GST filing and all those things. So these are certain, I'm not promoting them, but then I have used their services and I'm very happy with all these services. That's why I'm just giving you example. There will be multiple others, but then these are certain legal online platforms which will help you in making founders agreement. They'll help you in registering your company. They'll help you in getting your domain registers. They also help you in trademark and IP, but then I would not suggest them for trademark and IP. You should go with proper experienced IP agents like you have one, Mr. Vijay. Then next thing, you can check out Ministry of Corporate Affairs website, that is MCA 27. MCA 27, where you can find out which company names are available by yourself. It's a very simple task that you can do. Just go to the website and you have a company name in your mind. Just type that company name, search for company name. In this MCA services, that thing comes, search for company name and search for director. So you can search whether the company name that you are thinking of is available or not. Then next resource would be definitely when you are looking for names, trademark is the first thing that comes into picture. So for trademark, so initially to check which trademarks are available, you need to know the trademark that you are filing for belongs to which class. So there are multiple classes of trademark. I think there are around 35, 40. I'm not really sure. Probably Mr. Vijay can answer that, the number of trademark classes. But then there are pretty good number of trademark classes, like from 1 to 40, 45 something. So see, for example, for our cosmetic, pharmaceutical products or anything which is related to chemical, the class is 5 and 10, I think. Then there is some class 31 for business domain. So you have to go through the class of trademark and note down for yourself whatever product or service you are developing, it will fall under which class of trademark. So this trademark class, trademarkworld.co.in, there are many other repositories, but this one I use whenever I want to check the class of trademark. So you can check. Next is domain name. Domain name, simply you can use GoDaddy to check whether the domain name of your company is available or not. I would suggest if you have certain, registering a domain is not very expensive. You can get it for around 1,000 to 2,000 rupees. So that's what we do. So whenever we think of a domain name, we just get it registered. We don't know whether we'll be using it or not in future. But then we just get it registered for that period of 1 or 2 years, so that it does not go away. And we still have that advantage of having the domain name with us. Another resource you can use is Zomacorp. This is a very nice website wherein you can very easily type out and search whether that company name is available or not. MCA 27 is a bit more complicated. Zoba Corp is pretty simple because obviously it's not a government website, but then better to cross check on both Zoba Corp as well as MCA 27. Then comes your trademark search. So ipindia.gov.in, they have this website wherein you can, it's an open source website wherein you can very easily go and check for trademark. So once you know the class, see, I want to trademark the term something like so say Taurus Max, something like that. So I know that it belongs to. So I say that Taurus Max is a product which would be used as a chemical additive. So I can check which class that belongs to. So I can directly go and search on this ipindia.gov.in, and you'll will get whether that trademark is available or not. So this saves you a lot of time, because if you're giving that initial search, definitely the IP agent is going to do that search for you. But then if you do this initial search for yourself, you will save some money, first thing. Second thing is you will save a lot of time, because the turnaround time will be around 1 or 2 days when you give the names to your agent. They will do the search on there and then they'll get back to you. So it could be probably 1 day to 1 week. But then if you're doing the search yourself, you'll get the result in probably a minute or two. It's just a very simple process, and the report is generated in almost immediately. Then next comes your Google the patent search. So in past Google patents, there are a lot of other patent databases which are a bit more complicated than these. It's always better to get your initial patent search done from a authorized, a proper trained professional IP agent. But then it doesn't hurt to do it yourself initially, so that when you are forming the basis of your product, you have some idea that, okay, so say I think of an idea which is like probably a wooden scissor, random idea, which is like a wooden scissor. Now I want to patent it. You'll have to pay some amount of money to your patent attorney for doing the initial patent search. So if you do this initial patent search by yourself, you will have a very consolidated idea, and say you are ending up with 2 or 3 ideas, and then you can pay the attorney just for those particular ideas. So again, you're saving time and you're saving money. But then for your final patent search report, before filing the patent, now what is this patent search report? You say that you have come up with a formulation of some gel. Okay. Now you want to patent that gel. Now you want to see whether that idea is patentable or not patentable. Now what your attorney will do is, through those keywords and whatever materials you have used, the excipients that you have used, they'll run a patent search report, and they'll find out what are the various patents which are already available or not available in that particular domain. And then they give you a search report, and they say that, okay, this is patentable or this is not patentable. So this initial work you can do yourself, but then once you have consolidated on 2 or 3 ideas, it's always better, and it should be done that way, that you're getting the final search report through a patent agent. Now, these are the initial, the first stage, when you're forming the company, these are the resources that you could have used. The resources more or less remain the same for the next 2-3 more stages. So the next stage is when you're hiring your first employee. Okay. Now this is a very, very, very important stage. The reason being, it's a small team. So whatever the employee will be doing, he will know the whole and soul of the company. They'll know the entire know-how, the technical know-how of your product or your service. Your core R&D idea, they will know about it. So that's why it's very important to hire the first the employee that you hire has to be based on trust. And also there is something, even if you don't know the employee, there is something called as employee agreement. So in your employee agreement, you have these IP clauses. So whenever a new employee joins your company, you can get these employee agreements signed which have IP clauses. So there are some elements of employee agreement, IP elements of employee agreement. Obviously, there are multiple other HR related issues which you put in the employee agreement, but I'm going to talk only about the IP clauses. So you have your confidentiality clause wherein whichever employee is joining is not allowed to share your IP secrets with any other person outside work or even within work. Then also if the employee is contributing to the IP, so where will the ownership of the IP be? Okay, so like I mentioned before, there are inventors and there are owners. Inventor is just the inventor; they get the patent to their credit, but then owner is one who gets the monetary benefit of the patent. So the IP ownership issue has to be discussed with the employee. It depends on what stage the employee is joining and whether you want to give them any ownership or not. Also, there is something called as non-compete provision. Now, whenever an employee joins our company, we have a non-compete provision. So what is that non-compete provision? Now, when you leave the company, when you leave my company for 2 years, for next 2 years, you cannot start something similar on our domain for the next 2 years by yourself, or you cannot go and work with our competitor. So in this way, your your IP remains protected. Your IP remains protected, and you can make sure that the employee that you are hiring will not go and start something on his own, taking your IP, or probably go and join a competitor with the same IP. Also, whenever you're joining, whenever you're taking a new employee, you have to make sure the previous non-compete provision. So he or she is coming from some other company. So make sure if he or she is coming from a competitor's company, there is no this non-compete provision in his previous employment, because then there will be issues with that employee, with the employment of that particular employee. Now, next event will be a product development event. So here the individuals that would be involved will be founder, your employee. So for founder and employee, you have already your founders agreement, which Vakil Search, Clear Tax, and such India filing, such people can help you make. You have your employee agreement. Again, these people will help you make. Now, a lot of times we do not have our own manufacturing facility. So you will go to a third-party contract manufacturer. Now, when you're going to a third-party contract manufacturer, the manufacturer has your entire formula. Now, what about the confidentiality there? So again, you should have your very clear third-party contract agreement, wherein the procedures that you are using are well maintained confidentially with the third party, and also the IP ownership. So you have to make it very clear to the third party that the IP ownership is with us. You are just taking money and getting the product manufactured for us. Also, again, trademark is important here because your product is developed. You want to commercialize it in the coming few days. So trademark again is important here. Again, then next is when you're releasing your product, including beta release. Now, what is this beta release? Beta release is something wherein you're not really giving the product out in the market or selling it, but then probably you're just giving out certain free samples or a trial batch to a set number of people to take their response, how the customer is behaving with your product, how it is the customer response or the consumer response. So here again, third parties will be involved, consumers will be involved. So again, you have your license and agreements which will cover your everything right from patent, trademark, copyright. If you have a trade secret, you don't want to patent it, but you have a trade secret that has to be, well in place. Then you're using your web service. You're going to launch your website because you want the product to reach to people. So you have your website domain active. So there are certain terms and services of web service wherein it has to take care of the trademarks and it has to take care of the copyrights. There has to be no infringement. Whatever designs you're using for the website should not be from some other website copied, because then if they come to know, they can probably sue you for it if they have a trademark for that particular design. or if you're coming up with your own design, unique design for the website, you can trademark or copyright that particular design. So when you're releasing the product, again, the third-party licenses, trademark, and copyrights are important. Again, for marketing, I'm sure it is very logical that trademarks will be important. Then here also, a lot of times companies, they file for patent before entering the market, not when they start developing the product or once the product is developed, but then they patent it before entering the market. So according to me, this might not really be a good idea, because you take around 2, 3, 4 years for the product development, and then by that time, someone might have already filed a patent for your idea, and they will get the benefit of priority. So it's always better to file your patent as soon as possible. Then also, when you're marketing, you are using social media channels. So social media like Facebook, Twitter, Instagram, they have certain IP infringement laws wherein you cannot use a particular picture. So you need to be sure that all those terms and conditions of that web services and the social media channels are in place. Next comes when you're talking to potential partners, say for co-development or for co-marketing, or you want to get acquired. So here again, non-disclosure agreement is important. So always remember, whenever you're going ahead with any discussion, it could be with a mentor, it could be with an incubation center, it could be with a third-party manufacturer, it could be with an employee or anyone. Non-disclosure agreement is your best friend, because in this non-disclosure agreement, as the name mentions, whatever discussions is happening about your product, your service with that particular person, he or she is not allowed to discuss it with anyone else. So this is a way to protect your IP. It is the way to protect your IP, and it is extremely important before you get into discussion with anyone for that matter. So once you are into the startup ecosystem, you will get a lot of emails and calls for, okay, we want to fund your startup, give us a pitch deck, propose your submit your idea to us. When you're applying for grants, you are giving so many. So all these good grant portals, good grants, private grants and grants I'm talking about. Government, I don't know if they have that sort of a system. Within the private incubation centers and all, they have a non-disclosure agreement in place. In fact, I would suggest we have that for our company. We have a non-disclosure agreement in place. So we have all these contract research organizations we partner with for doing some testing of the product, some LCMS method development, or some animal study we are getting done with them. So we have a non-disclosure agreement format ready. We make certain changes, and before we submit any product or any data, or they give us any data, we have this non-disclosure agreement signed. So it's always better to be cautious than to repent later on. So these were certain resources and resources that you could use at various stages of your IP management at the initial stage of your company development. Now there are some other tips. So a lot of times how we start a startup is we are already in an employment, we already have a job, and we think of something. So we are in the job for another 1 or 2 years, we build up on that idea, and then we exit the job and start our own startup. So in such cases, I'm sure the management will not like this, but then in such cases, it's important that you keep your IP from your employment work separate to what you want to do. So a lot of times, say you're working for an F&D organization, formulation development organization, and you want to start a company also in formulation. So it's always better that if you know that, okay, I want to start with this particular concept, don't mix it with your work concept. Then you will be in problem. Same thing happens with, say you are in an academic organization, you develop certain products and you want to file an IP of the product. So a lot of time in educational institute, how it happens is the ownership of the patent lies with the institute, and inventor is the faculty or the research scholar. But then if you feel that you want to you want to commercialize this particular project, this particular product, it's always better to file your patent on your own and be the owner of your, even though if it's not a company yet filed, but then you can be the owner of your own patent, so that in future, whenever you want to file for a start a company and commercialize that product, you will get the benefit of it. Also, it's always better to have a agreement with the organization, with your institution, the educational institute, of what will happen if you file a patent, if the inventor, so you being the faculty are the inventors and the educational institute is the owner of the patent. So have an agreement well in place before filing of the patent, so that if the patent gets commercialized, if the patent is sold to a company, what will you get in return? How the monetary benefit of it will be shared. You are going to get it in your CV and on your the patent credit to your name as an inventor. But what about the monetary benefit of it? Okay. So the ownership details should be well discussed with your employment organization. Also, whenever you are starting, uh, so filing an IP, be it trademark, be it patent, it requires money. Okay, it does require money. Now, there are certain ways, there are multiple organizations which fund, even the government funds for filing of your IPR. So make sure that in order to monetize and in order to make sure that it's a cost effective process, you evaluate what type of IP is more important for you. See, for example, for a formulation, probably a design is not that important. I can file it later on. But then my patent for my composition is important. So I'll first go ahead with patent and then I'll go ahead with, as and when I get money, I'll go ahead with other forms of IP. Then, then also consider a global patent strategy, including China, because a lot of times we feel that China patent doesn't really matter, but then there are new laws which have come up. So don't just concentrate on India, concentrate on the global this thing. Again, one more, this is my personal understanding and personal feeling. A lot of time academicians, they file for US patent and US patent. But then if you do not have any intention to commercialize that particular product, just file Indian patent. That will be good enough for your portfolio, good enough to show in your CV and for performance-based appraisal. Filing a US patent will unnecessarily add to the cost of it. So there's this another thing which I want you to know. BIRAC. BIRAC is Biotechnology Industrial Research Assistance Council, which comes under DST. So they have this Law Clinic Connect, wherein they give free advice to startups and innovators from India on various types like patentability criteria, technology transfer, all the IPR and regulatory related aspects. So definitely I would suggest that go through BIRAC website. You will find the details of this. They have, I think it's once a month affair and you need to take appointment earlier. And good thing is now it is done on video conferences. Earlier it was only in the Delhi office, but now you can avail the video conferencing facility. So then apart from this, there are certain other things which you should know. So government of India has this facility wherein for Indian startups, once your patent is granted, so I have my patent granted, I am a startup registered in India and it's a DITP registered startup. You have your patent granted. You can get reimbursement for your patent filing of up to 2 lakh rupees. So that's a very nice initiative what the government has done. Another thing is for DIPP registered startups, there are patent facilitators. So when you want to file a trademark, the government fees is I think around 4,000 or 5,000 rupees, and the attorney takes 4,000 to 5,000 rupees. So for filing a trademark, one trademark requires around 10,000. It's around 7,000 to 10,000 rupees, depending on what attorney you're going with. So government has these patent facilitators, IP facilitators, wherein these facilitators will file your trademark for free So you just have to pay, you do not have to pay the professional fees, you just have to pay the government fees. So there is a list, you will usually find it on the website of ip.gov.in, list of facilitators. You can find one in your city who do the trademark filing if you're a startup, if you're a registered startup for just with the government fees. So that's it from my side. There are multiple other grants and funds which are available specifically for IPR filing. I can share a list with Dr. Kamlesh if you all want it. And I'll have to make a this is exhaustive list, and we have used a lot of them. So I can share that list with you. So a disclaimer, whatever was presented in this presentation are my own personal opinion and what I have experienced and what I have actually implemented. And this is not any legal advice. I'm not I'm not a professional for any legal advice on IPR, but then this is from being from a founder's perspective, from an entrepreneur's perspective, how you can manage your IP and initial level, what all resources you can use so that it becomes easy. And always getting help from a professional attorney is must, not better, but it's must. So, but then why I wanted to share these resources is unless and until you do your homework, you know that what type of IPR is there, what patents, you don't do your initial search report and you go to the patent attorney. If you go to the patent attorney well studied with all the facts clear from your end, it's easier for the attorney to fight your case well. So that's why I wanted to do this. Yeah, thank you. So, ma'am, I just want to quickly talk about my company for a minute or two, if you permit.
Please, ma'am, please go ahead.
Yeah. I'll just quickly share. I just want to share a pitch deck. I am founder for two startups. One is Relicus Healthcare, which is into generic branding and manufacturing, generic branding and third-party manufacturing, distribution of generic pharmaceuticals. I would like to talk more about Cerelia Nutrients, which is so we are an OTC pharma startup, which we are developing patented transdermal technology products which are focused on multivitamins. So the problem that we're trying to solve here is the 1 in 3 people present here, we suffer from some or the other type of micronutrient deficiency. So major deficiencies are B12, iron, folic acid, vitamin D3. Now, since you all are from technical background, you know that these supplements, they suffer from low oral bioavailability. If you see the leaflet, the inserts of in a B12 capsule, you will see that the amount that they put is sometimes even 200% of your RDA, 300% of RDA, 30% of RDA. So why this extra? This extra is to compensate for the loss in the GI tract. Also specifically for iron, when you're taking iron orally, it leads to GI irritation, bowel discomfort, nausea, vomiting. And iron and folic acid are majorly prescribed to pregnant women. So what we thought that we should develop a nutrient supplement which which is not just which is not just which is which the people are not compelled to use, but they like using it. Especially women, pregnant women, government spends close to 26,000 crore on various nutrition initiatives. There is this one initiative wherein they are giving iron and folic acid tablets for free. Now, even though the government is giving iron folic acid tablets for free, only 35% of women like taking them. The reason was very simple. They either faced nausea or vomiting problem in the morning, or especially in the rural area, we actually did a ground survey in the rural parts of Odisha, which is one of the most challenged areas in terms of when it comes to statistics about nutrition deficiency. So what we found out was a very one thing was because of patriarchy, the women were allowed to eat at the end after the men, the kids, and elder women of the family are done with the eating. So they are compromised with their nutrition. when the government or the Anganwadi Behenji was giving them free iron folic acid supplements, the mother-in-law sometimes would give it to the husband to eat, saying that okay, you don't need to be strong, but then my son needs to be strong. Or a lot of times they had this very stupid, how considering how we Indians are obsessed with fair skin. So when you take iron capsules or tablets, the stool color changes to a darker brown or black sometimes in color. So what the women thought there is, if the pregnant lady is consuming iron tablets, the baby that would be born would be darker in color. So they would not let the pregnant women take these tablets or supplements. So we thought of coming up with something which would, overcome the biological problems plus these social stigmas associated with iron and folic acid supplements. So that's why we have come up with a solution wherein we have a moisturizer with encapsulated micronutrients. So it's our patented technology. Our patent is granted for this particular technology. You just need to apply it over the skin, and the nutrients are delivered from the skin into the blood. So we are able to achieve up to 50% dose reduction because the formulation is higher and there is no loss due to the acid pH of the stomach. So as compared to oral solution, our bioavailability is around, relative bioavailability is around 67%. So this is my super amazing team, and so we have around 7 products in the development. 3 of them are into human clinical trial right now. Yeah, so from 2016, since our inception, we have won several awards and grants, and 2 patents granted, 5 trademarks granted. Yeah, thank you.